It's really great to see everybody here, and thank you especially to our guest, Gail Davidson, who's a retired human rights lawyer. I tell you, Gail, I sure wish I known you 2.5 years ago. It would have made my life probably a whole lot better and easier. Maybe not, I don't know. Gail is based in the Metro Vancouver area, and she was just a little bit under a year ago, she was actually a witness at the National Citizens Inquiry at their Vancouver hearing. And her testimony and handouts and so forth that she had, that was all shared with you in newsletters previously. She did have a handout that she's asked us to share with you today. And Diane, I think, has already sent that out. And with that, I'm just going to turn it right over to her so that we can hear from her about some of the things that would be very helpful to know. So thank you so much, Gail.
Good evening, everybody. Thank you for inviting me to be here. Before I start talking about the vaccine mandate and the international human rights law that applies to that, in my opinion, I just wanted to say to you, to the BC Public Service Employees for Freedom Association, that thank you for the work that you do to continue to expose the wrongdoing and illegality of the vaccine mandate that was imposed on you, and to try and get remediation for victims and some accountability for those who were responsible for the mandate. And also, I just wanted to caution you that as a retired lawyer, I'm a very different person than a lawyer. And so I can't, I'm not authorized or licensed to give advice, so don't take anything I say as advice. What I have for you tonight is some information about the law as it applies to the mandate, and hopefully will be of help to you in your very important work. So having said that, I'll just launch into my comments. I'm going to talk first about what didn't happen when the vaccine mandate was imposed on the BC Public Service employees. What happened, as I understand it, is on October 5th, 2021, employees were advised by email, of all things, that all employees, including those working remotely, would be required to be fully vaccinated with one of the products designated as COVID-19 vaccines as a condition of continued employment. Anyone not fully vaccinated by 22nd November would be placed on unpaid leave and then fired at the end of 6 months if no proof of vaccination had been received. The requirement to provide the employer with proof of vaccination clicked in on November 8th. And the email, the first email that I saw anyway from Laurie Wanamaker, coyly said further details will be provided by November 1st. The mandate was, in my opinion, and is wholly illegal. The international law, and I'm talking about law that is binding on Canada, according to the Supreme Court of Canada, recognizes two categories of rights. Derogable rights are rights that can be conditionally restricted for the purpose of preserving other rights, both in a non-emergency situation and in an emergency situation. Non-derogable rights, which are also called absolute rights, are rights that can never be lawfully restricted, even during a pandemic or a war. The mandate in question violates both kinds of rights. In addition to causing grave harm to affected BC Public Service employees, their families, and communities, the mandate also sets a very dangerous precedent and paves the way for the tyrannical imposition of other clearly unlawful measures that violate or extinguish rights guaranteed by the current Canadian law and international human rights law. And this kind of lawmaking signals the end of democracy, in my opinion. So I admire people who have the courage and generosity to keep peacefully resisting. I'd first like to talk about what was not done with respect to the mandate that should have been done. No one was advised of the information upon which the vaccine mandate was actually based. Instead, employees were told, again by email, and I quote, "Vaccination against COVID-19 is without question I'm trying to imitate Bonnie Henry, in the public interest. The vaccines are proven to be safe and effective, and that is an evidence-based determination made by expert colleagues across the public service at the provincial and federal level," close quote. And that apparently public service employees were just supposed to take that as the absolute truth. The evidence referred to was not identified or provided. Employees were given no access to the information needed to assess this emailed statement or to assess the efficacy, safety, or necessity of the vaccine mandate or the evidence relied upon by those imposing it. No reasonable notice was given to the employees who were likely to lose their income, employment, and benefits simply for exercising their right to accept or reject medical treatment or medical experimentation. No data was provided to reasonably support the statement of safety or efficacy, or even the statement that the vaccination of all BC Public Service employees would, quote, this is from another email from Lori Wanamaker, "help us overcome COVID-19, close quote." Employees were not advised of their legal rights to informed consent to medical treatment, or of the fact that all the products offered as vaccines were still experimental. So therefore, they were being compelled to participate non-consensually in medical and scientific experimentation. Employees were not told that both Canadian and international law prohibit absolutely non-consensual medical or scientific experimentation on humans. Employees were not told that the law prohibits the use of force or coercion to compel acceptance of medical treatment not voluntarily chosen, and were not told that the use of force or coercion to compel acceptance of a medical treatment is prohibited by the UN Convention Against Torture, to which Canada is a state party. No advice that employees not wanting or able to accept injection were entitled to legal representation and to legal aid if needed. And no legal aid, of course, was provided, which it was a wrong in my view as well. No mention of the employer's legal duty to accommodate disabilities that precluded injection, other than a very vague reference to the BC Human Rights Code in one of the emails. No allowances for alternatives to non-consensual injection and non-consensual experimentation. No reasonable opportunity was given to obtain an exemption, I should say, or to contest the legality of the mandate based on personal factors or based on law. No access was afforded to effective remedies for the harm known or reasonably anticipated from the mandates, including injuries and losses associated with loss of income, benefits, and employment, vaccination itself, loss of housing, depletion of assets, increase of debts, health repercussions, etc. So let's look now at what was known to the responsible officials in October of 2021. It was known that the products marketed as COVID-19 vaccines were clearly experimental on the following basis. The products were novel for use on humans, and the virus itself was novel. There were only 2 months of the data from studies, so there was no data to establish short-term, intermediate, or long-term safety or efficacy of the products. The Pfizer's own documents at the time that they were given emergency approval states that the products were still experimental, states the obvious that the products were still experimental. Next, what should have been done? The rights to freedom from non-consensual medical experimentation and freedom from force or coercion to accept a medical treatment not voluntarily chosen, and should have been were known to be absolute, and that any restriction by anyone, anytime, anywhere was prohibited by Canadian and international law. Interestingly, Canada had in 2020 been before the Committee Against Torture on the use of force or coercion to force to compel people to Indigenous women to accept sterilization, and the Committee of Torture told Canada, no, that's prohibited under the Convention Against Torture. So Canada was well aware of that. It was also known that the right to informed consent to medical treatment is guaranteed, and that it must precede informed consent must precede every medical treatment. It was also known that fully informed consent is consent based on full information given about the known and reasonably anticipated risks and benefits of the treatment, the possible risks that are particular to the individual, alternatives to treatment, and the consequences of no treatment. Now, another aspect that Canada knew and admitted to the Committee Against Torture, that the information must be given by the health professional who will administer the treatment. To give informed consent, the person receiving the information must be capable of understanding the information and have full capacity to make an independent decision free from fear of punishment or other negative repercussions as a result of refusing treatment. The authorities, in my view, therefore must have known that the imposition of the mandate that was imposed on the BC public servants in October, November of 2021 was unlawful altogether. That there was nothing to justify it or make it lawful. So next, I'd just like to look briefly at what should have happened. What should have happened is that the BC governments and all governments should have provided and ensured disclosure of the information and the debate and oversight necessary for the people impacted, the public, health professionals, legalists, to assess the safety, efficacy, necessity, and lawfulness of the mandate, and then to accept or reject it. It was also should have been provided access to information about early treatment and prophylaxis. There should have also been provided access to medication and other products for early treatment and prophylaxis. And of course, these were not only not provided, but the information was suppressed, and health professionals were even lost their licenses for suggesting that people use products other than the vaccine as a treatment, because the vaccine was marketed both as a vaccine, which it wasn't, it didn't provide immunity, and it was marketed as by the Canadian governments anyways, as sort of treatment. States should have ensured adherence by both state and non-state actors to Canada's international law obligations to prohibit restrictions to all non-derogable rights and to comply with international conditions for restrictions of derogable rights that include requirements of lawfulness, necessity, legitimacy, proportionality, temporariness, and access to review. The temporariness, you think, oh, well, that's not a very important condition, but you'll notice that a lot of the some of the orders that came out of that were issued by Bonnie Henry at press conferences don't contain any temporariness portion to them. Also should have been provided is parliamentary oversight, debate and acceptance or rejection of the underlying policies and the mandates themselves. And lastly, what should have been provided was equal, effective, and timely access to proper judicial oversight that included provision of legal aid for employees threatened with loss of employment and loss of income. Obviously, like some of these things are just obvious. And then I want to briefly say, look to briefly question what should have happened after it was known that the products marketed as vaccines were not safe or effective. And I'm going to suggest that we use the date in the Perlator decision, which was a very generous date to the state officials of June 2022. And once it was known that the vaccines did not prevent infection, transmission, serious illness, or death, once it was known that the vaccines, in fact, caused serious injuries and death, the state was legally obliged, that's our state, to ensure independent, competent, transparent investigations that are capable of leading to proceedings to determine the facts, identify and impose accountability on those responsible, and identify and grant reparations for victims. And of course, none of this has happened. Because the harms resulted from actions that were either promoted, allowed, or imposed by state agents, any such investigations have to be, according to international human rights law, carried out by, obviously, by independent investigators that are independent of the state. And none of that has happened either. In fact, now the cleverness of stripping people summarily of their income is that it incapacitates them basically from, somewhat incapacitates them from seeking remedies, because seeking remedies costs money. And of course, that's further barred by the fact that there's no legal aid provided, and further barred by the fact that in Canada, perhaps that's not true now, but initially there were very, very few lawyers that were willing to take cases contesting any COVID measures or mandates. And the third problem, of course, is that once some lawyers were available, those lawyers were very hampered in conducting an effective challenge because of a terrible inequality of arms, as they call it. In other words, the state had endless, almost bottomless resources and could afford to delay things by not producing documents. Another thing that litigants have faced is the lack of, what I see as lack of impartiality, maybe lack of competence, maybe lack of independence. I don't know about the latter two. Not all courts, of course, not all judges, but many of them have simply said that we're going to invoke an unusual principle of judicial notice. We're going to take judicial notice that anything that Health Canada said about the vaccines, for instance, is the truth. And that's as true as saying water is wet. I will not hear any evidence on the wetness or dryness of water, because it's uncontroversially known and accepted that water is wet. So they applied that same thing to vaccines being safe and effective. If Health Canada said that, then it is. And so that further hampered the use of judicial oversight to right wrongs and to be an effective safeguard against the misuse of power by state agents. So then I just want to finish up by saying what can be done now? Well, internationally, BC Public Service employees for freedom could submit reports and complaints to the United Nations treaty monitoring bodies that identify the unlawfulness of the mandate and the injuries caused, and seek recommendations for remedies. Although all of the UN human rights bodies decisions, none of them are binding on Canada, but I've worked in that field for over 20 years, and I would say that they sometimes are quite effective because other states know about them, and they're embarrassing, and Canada is required as a member of the United Nations to reply to the allegations and to reply to the decisions. And domestically, of course, the public service, the BC Public Service Employees for Freedom can keep doing what they're doing, is working to provide wide public access to the facts, the fraud and misrepresentation used to compel compliance with the mandates, the outcomes of the mandates and outcomes of alternatives to the mandates, harms caused, rights violated, remedies needed, and so on. Also, it's very important, these, for instance, your meetings, I think, are very important. It's very important to provide more opportunities for public debate, because during COVID, freedom of expression was very criminalized for many people. And in a democracy, as you know, the lifeblood of a democracy is conversation and debate at every level, and conversation and debate and participation in decision making. So that's a wonderful thing to do, and also to disseminate knowledge about the need to engage in expression, dissent, and decision making in order to protect rights, the rule of law, and democracy, and also to continue just to provide information about civil proceedings that can be initiated by individuals and groups to ensure remedies and guard against recurrence. And those are my remarks for the time being, and I'd just like to now have a discussion with you and answer any questions that you might have.
Thank you, Gail. That was really interesting. I will just start with a question, just because I'm going to take advantage of being the host here. Is it ever okay for an employer to require some sort of medical treatment or something? I'm thinking, for example, if you're a pilot or if you operate a crane where your work has the potential to seriously harm someone or kill them, or if you're not in good shape to do that job, you might cause a very expensive accident or something. Is there any sort of a time when an employer could do that?
When an employer can ask for a medical assessment of your abilities?
Or require some kind of medical treatment in order for you to do your job?
No.
No.
Well, I'm going to rephrase your question.
Yeah, sure. Okay.
Of course, an employer can ask for and obtain a medical assessment of a person's physical and mental capabilities to do a job. So, of course, I mean, for instance, even the superintendent of motor vehicles can insist that a person have a sight test in order to get a driver's license.
Mhm.
That makes sense. The employer couldn't to say to a person you have to take a particular treatment. No, because if the employee failed the sight assessment, for instance, to be a crane driver, and the employer said, well, maybe if you had glasses, you would pass it and you would be able to do, but that's up to the employee to get the glasses or lose the job. but obviously it's up to the employer to make sure that the employee passes the things that are physically necessary for the person to do the job safely.
Right. Okay, thank you. Okay, I see we have Mike has his hand up, so I'll turn things over to Mike. Please go ahead.
Good evening. Can you hear me all right?
I sure can.
Okay. Hello, Gail, and thank you so much for this presentation. I also watched you during the NCI hearings, and you spoke so eloquently, and it touched a lot of people in very important ways. So everything that you've said tonight is accurate and undeniable. There's countless BC public servants that stated many of these same things in the early days, and they were relentlessly and repeatedly coerced and ignored, ostracized, and penalized by being publicly mocked and placed on leave without pay and or even fired. So over the past 2.5 years, the unions, the legal systems, and even the medical professionals seem to have abandoned their duties to safeguard us, and they've thereby caused great harm to many. A tremendous amount of the public have completely lost faith in the systems that they thought was there to protect or defend them, and so many have now given up the fight. So what would you say to help re-inspire people who feel that continuing to fight is now a lost cause because the systems seem so completely corrupted?
Okay, what a wonderful question, Mike. We could just talk for another hour or so about that. But I would say a lot of things. I would say that it's very doing any kind of human rights advocacy is always discouraging, and it's always necessary. And it's I just want to quote Mussolini. You know, Mussolini was talking about how to impose fascism or totalitarianism, whatever. He said it's like plucking a chicken. You have to pluck one feather at a time. So nobody really notices that that chicken's being plucked until all the feathers are gone. I know that's kind of a stupid thing, but it's the same way with the restriction and extinguishing of rights and the imposing of undemocratic mandates and policies. We just have to all find a way to keep on, to do anything, to do any small thing, and then to do it again with others, because that is the only way that we're going to keep our democracy such as it is, and to maintain our rights. The things that happen in COVID were obviously just a preliminary to what else is coming. In May of 2024, we're almost there. The international health regulations will be approved, and the pandemic preparedness treaty will be approved. And the one of the things that the co-chair of the International Health Regulations Working Committee said is that I'm now not quoting him, I'm paraphrasing him. His name is Mohammed Shiri, I believe that's his last name. And he said civil liberties is what he calls rights. Civil liberties got in the way of enforcement, and we can't let that happen again. So, you know, Canada is one of the 7 countries that has joined that has signed the so-called Agile Nations Charter, and that's also directed at getting rid of regulation and other things like rights that stand in the way of enforcement. So I just think it's so important to urge people to do any small thing. It doesn't have to be a big thing. It just has to be something that you do, hopefully every week, to say, my vote is no for this. I say no to this.
Thank you very much. I appreciate your comments, Gail.
Thank you, Gail. Zorba, I see your hand is up next.
Yeah, good evening all, and thanks, Gail, for joining us tonight. I just would like to hear your opinion about the employer through the exemption process allowed for the employees to oppose the mandate or vaccination based on one of the grounds protected under the Human Rights Code. But the Human Rights Code, obviously, for the absurdity reason, didn't address rights of a healthy people, and also to comment on the employer's ignorance and discrimination based on the immunity status for the employees and British Columbians who were infected by COVID and recovered, and therefore attained the so-called natural immunity or post-infection immunity that's been again recognized by the science as equally, if not better than the 2 doses of vaccine. So if you can maybe comment on that, I would appreciate. Thank you.
Okay, so first of all, starting with the BC Human Rights Code, first of all, I have to tell you, I don't know anything about the BC Human Rights Code. One thing I do know is that the BC Human Rights Commissioner came out very oddly early on in the COVID situation and in favor of COVID measures and mandates, which is a very strange thing to do. So going to the Human Rights Commission doesn't seem on its face to be very likely of success. But the provisions under the Human Rights Code, I imagine, refer to the prohibitions to discrimination. So I don't really know what they were meaning, what that vague reference meant in the email that I read. And as to your other question about the mandate applying to people who had natural immunity, well, it also applied to people who were working remotely. None of it made any sense, and none of it was science-based, obviously. It was all based apparently on pronouncement by Health Canada. And I guess the reason why there was kind of a network coming down. So early on after COVID, like in May of 2020, the Chief Justice of the Supreme Court of Canada formed a committee called, I think it was called the Judicial Action Committee. And David Eby was a member of that. It was a very small, David Eby and Lametti was then the Attorney General of Canada, and David Eby was then the Attorney General of British Columbia, and the Chief Justice of the Supreme Court of Canada, and there was a couple of civil servants and a couple of other people, not very many, and they decided right then at the very beginning that the very best, that the courts would be run and they would be directing courts to operate according to the very best science available, and that would be directions and pronouncements by Health Canada. Now, you know, there's a study posted on the Canadian COVID Care Alliance about the co-option of COVID of Health Canada by the pharma industry. So it's questionable whether how Health Canada came to make their statement. So if Health Canada said the vaccines were safe and effective, we don't know to this day if Health Canada was basing that on something that on what, we don't know. So why they were obviously they weren't basing what they said on science, or they wouldn't have said it. That's my point. So why would they have bothered with science when it comes to persons with natural immunity, and the data established that natural immunity lasted for a lot longer and was more robust than the short-term immunity that some people got from being double vaccinated, although they never got any additional from being boosted. So does that answer your questions?
To some degree, but yes, thank you for addressing that.
Thank you, Zoran. Okay, I see Pixel 4 XL has a question. Over to you, Pixel. You're muted. Please go ahead. You're still muted, it looks like. Maybe just while we're waiting for Pixel to unmute, Gail, I will, I don't see any other questions in the chat. Oh, are you there, Pixel? Oh, no, okay. I don't see any other questions in the chat at the moment. So I have another question for you. Is the fact that there was some sort of public emergency, does that make a difference to anything? So if there hadn't been a public emergency or a health emergency or whatever it was, would that have changed anything in what you've said?
Okay, the answer to that is obviously yes. And the answer to that, the next answer to that is yes, but it didn't allow it. It didn't. The law on emergency measures didn't allow what happened. So the reason why the answer is yes is because what the government did at the provincial level and at the federal level, they said, well, the WHO has declared the COVID-19 virus to be a global pandemic. So then the government acted as if all bets were off and anything was allowed. They took the position that now that an emergency had been declared, they could do anything that they decided behind closed doors on the basis of unknown information. They could do whatever they said was necessary. And of course, if that were the way the law worked, well, we wouldn't have any law, right? We wouldn't have any democracy. We wouldn't have any rights. Obviously, the next answer to it is yes, the declaration of a democracy an emergency changes some things, but like to put it in a shortened form, all that the declaration of emergency authorizes is the measures that are necessary to protect rights. So they were saying, oh, it's necessary to protect rights to vaccinate everybody, to have universal vaccination. But that was never, even if that was what they were saying, that still is not legitimate when the evidence upon which that's based is kept entirely secret or is released partially in a way that is either misrepresenting or capable of being misrepresented. And if discussion and analysis is censored, prohibited, and punished, all of those things happen. So nobody could ever see the data to say, is there really a pandemic? Who's really at risk? When they said, well, old people were at risk. Well, of course, old people are more at risk of dying than young people, generally speaking. I mean, that's almost something that you could take judicial notice of. But we were never provided with the data to assess anything, and that was a tyrannical, dictatorial stance to take. That is not what you do in a democracy when there's an emergency.
Right. Okay, thank you. I see we just have a few more minutes and we have 3 hands up. I'm going to start with Pixel, if we can get Pixel again. Can you unmute? Okay, please go ahead, Pixel.
Can you hear me now?
Yes, yes, thank you.
Yeah, sorry. This is Ocean. I forgot why my name shows
Oh,
Pixel
okay,
Fly.
Ocean. Oh, sorry.
Yeah,
Please go ahead, Ocean.
that's okay. Yeah. So you mentioned that Health Canada was making a statement, and then the BC government used that statement as a evidence or as a excuse to enforce the mandate. So is it legally a way that allows BC government to use Health Canada's statement as a evidence or as a base to do so?
Is it legal that they do that? Is
Is it defined in the law to allow it?
No, it isn't. I mean, you can't. Okay, so on the one hand, somebody could say yes, and on the other hand, somebody could say no. But I would say no, of course not, for this reason. Otherwise, an unelected, essentially unaccounted official in Health Canada could say anything ridiculous that then would be the law, and that can't be the law. If you see what I mean, is that clear?
I mean, any law, is it any law that allows the BC government to use Health Canada statement as a base to announce new restriction or new regulations like that?
No, there isn't anything in law that says that once Health Canada says something, then that applies and that is the truth and that can't be examined or contested. There's no law that says that, no.
Okay, so we are able to fight the government saying that there is no law that allows you to use that as a base to enforce the mandate. Is that right?
That's correct. However, as I say, way back in May of 2020, the Chief Justice and the other people on the Judicial Action Committee put out this directive to all the courts across the country saying the very best information in this very difficult and frightening time is whatever Health Canada says. So what has happened in a string of about 21 cases in Ontario is that judges of different courts in Ontario started saying, I'm going to take judicial notice of the safety or the efficacy of the vaccines because Health Canada said they were safe and effective, so therefore they are. So although there isn't a law, it was the law in some cases.
Thank you, Gail.
So it's just by the comments of a certain justice.
What did you say?
So it's just by the comment or the president of the comment of only one certain justice
That's
that
right.
makes the legal effect.
Yes. Yes.
Okay.
Okay. So is that in written? Is it in written? Or it's like just an oral thing?
Oh, what the Judicial Action Committee said, is that written or oral?
Yes, I think that was the question.
It's on their website. And if you go to the Wayback website, you'll see what they published on their website from the beginning, which was May of 2020.
Okay. Okay. Thank you.
Right.
Thank you. Okay, we just have time for a couple more questions. I hope, is that okay, Gail? We're just on the hour now. I see Zoran wants to do a follow-up question about the declaration of emergency. So maybe Zoran, I'll ask you to go ahead, please.
Thank you, Dale. Yes, I'm just wondering your views or opinion on the. I recently run into a BC Society Law Society podcast they have around the rule of law in the time of COVID, and the guest was in one of the episodes the ombudsperson for British Columbia, and the question was around that COVID-related emergency power issues, whether the executive branch had the power embedded in a statute to enact the laws, expressly delegated that kind of a power to the executive branch. And the idea was kind of expressed that the Supreme Court of Canada, when it comes to expression of public power must find their source in the law. So they looked into that kind of a source of law in British Columbia, and he looked into Emergency Program Act that was passed by the Legislative Assembly. And he could not find anywhere that act says that, and I quote, that act did not say that the minister can make a suspend laws. It didn't expressly say that. So, and making a law is such an important function that if this is something that the minister could do, we would expect that it would be clear and unambiguous in the legislation, and it wasn't. And it's not something that should be implied. So if that is true what ombudsperson said, I'm really perplexed to why a law society didn't write a letter to then Attorney General David Eby, and particularly in regards to the mandate for the public service that affected 45,000 people. I'm just, curious about your views or what I just said, and whether that's an area to explore and attack and hold the government executive branch to account.
Okay. What did the Law Society say to Attorney General Eby?
They did not say, but I'm saying, what do you think? Why the Law Society, if that is indeed true, what the ombudsperson found, that the Emergency Program Act doesn't give the executive branch specifically to that legislation to use the emergency to suspend other laws or to bring mandate to that effect.
Right. Okay. So
it has to be legislative branch, not the executive branch.
Yes. So I can't really comment on what the Law Society should or shouldn't do, because I think that the response of the legal community in Canada to the COVID measures and mandates has been not good. So when I got called to the bar, I swore an oath to uphold the rights of all. Well, obviously, the mandates summarily violated the rights of all, including people who complied. Their rights were violated too. And so now, as to emergency measures legislation in British Columbia, whether that gives the right to ministers, the right to appointed people, the right to non-elected, non-accountable bureaucrats to make laws. Yes, it does give those rights to those people. The new BC Emergency Act and the BC Healthcare and Professions Act, which has an emergency measures section, they both allow emergencies, local emergencies, municipal emergencies, regional emergencies, provincial emergencies to be declared quite summarily by the minister, and sometimes by with the emergency legislation, they could be declared by a mayor or by the provincial health officer, and they're just can be imposed, and then very drastic measures can be ordered. So that's one reason why I think the work that the BC Public Service Employees for Freedom is doing and other dogged litigants is so important because these laws have to be pushed back.
Thank you. Thank you, Gail. Is that okay if we go on to the next question? I'm just noticing the time here, Zoran.
No, yeah,
Okay. That's it?
thank
Okay,
you.
thank you. Justin, we have your question, and then if it's okay with Gail, we'll do one more. So Justin, you're up.
Hi, thank you for your presentation. That was excellent. Just so you had mentioned your suggestion to make appeals to the UN Human Rights Tribunal.
There's a lot of different special mandate holders and committees that you could make appeals to.
And would you be able to provide us with a list of those, and then what areas of the law we would be looking at? Like, so, because it's all, for us, it's broken up into many different pieces, right?
Well, as you know, I can't give any advice, but I can give you information. And so I'm not advising you to do those. I'm just saying this is something that human rights advocates do that I think is quite effective. But certainly I can do a couple of things. I could send you a nice PowerPoint that shows you all the different groups. And then once I've sent you that, we could you know, have an email exchange or something of that nature. I'd be happy to provide you with more information about that.
Awesome. Thank you very much.
You're welcome.
Oh, sorry, just a follow-up question to that question quickly. So of course with the UN, is this tribunal or oversight body, what is the level of independence in your opinion?
Oh, that's interesting. Like one of the I mentioned special mandate holders. Those are special rapporteurs. That's the easiest way to make a complaint or a call for urgent action is to a special mandate holders. There's about 50 of them, I guess, that work under the umbrella of the UN Human Rights Council. And that's a really interesting question because they don't receive any pay. They're appointed and they have to just do their work and get their income somewhere else. Many of them are university professors, and they have each special rapporteur has 2 employees that are paid by the Human Rights Council budget that work in Geneva. And so and of course there is politicking that goes on in the appointment of the special mandate holders. Like anybody can nominate, NGOs can nominate special rapporteurs, but there is politicking that goes on. But given those things, so many countries wouldn't like good people to be appointed. But having said all that, there are some fantastic special rapporteurs that certainly demonstrate independence and make, you know, careful and hard-hitting decisions. Yeah.
Thank you very much.
You're welcome.
Thanks, Justin. Okay, our final question is from Brett. Please unmute, Brett, and go ahead.
Hi.
Hi, Brett.
Yeah, regarding the politicians responsible for firing us and violating international human rights law, do you have any thoughts on what could explain their brazenness and legal recklessness? Do you think any of them are vulnerable to criminal prosecution?
That's an interesting question, and I don't know the answer to that, and maybe we never will know the answer to that because as I understand from the ongoing litigation, the government's being very fiercely opposing disclosure of information and documents. And so the only way that there would be, that I can see of, that there would be criminal prosecutions was criminal prosecutions based on criminal fraud in promoting the, for example, the vaccine mandates. So did they actually know So I don't know about that. But the other part of your question is why did the politicians responsible for firing of the BC Public Service employees, why did they go along with it?
Yeah, I mean, they must have had a lot of long discussions with lawyers about the possible legal jeopardy that they could find themselves in doing this. So,
yeah, I have no idea of the answer to this question, but just knowing a lot about human beings, I would say that, yes, I agree. They must have had lots of conversation with lawyers, but there must have been a drive when talking with the legalists that they talked with is, how can we get this through? So I don't see that there was ever a drive of saying, is this really the way that we should go legally or should even go factually? Mandates and locks down and so on. I think that it started, the discussion always started with whatever the legal barriers are, how can we overcome those barriers or make sure that they're never raised in order to put these mandates through. So the question in my mind is, why did so many elected representatives, whose job it was to act in the public interest, not in the corporate interest, in the public interest, why did they so strongly promote in this, what we're talking about, vaccine mandates, apparently to the extent of feeling that they had to suppress, punish, and prevent dissemination of any information that indicated that the vaccines might not be effective, might not be safe, might be very harmful, in fact, and even punish that information. I mean, it's why? I don't know why.
do you think it was a form of discrimination that this mandate was only imposed on select British Columbians, not all workers?
You know, Brett, that's a very interesting thought to raise, and I hadn't even thought of that. I did think of the fact that I have thought of the fact that two of the groups who were targeted with early vaccination were old people in care homes and First Nations people. I did think that seemed to me, probably because of my own way of thinking, that seemed very prejudicial to me. So,
Okay, thanks.
are very discriminatory, I should say. Yeah.
Is that the end of your question there, Brett?
Yeah, that's everything. Thanks.
Okay, well then I guess I'll wrap things up by saying thank you. And Gail, I'm not sure if you've had an opportunity since you're answering questions, but there's been quite a few comments in the chat, and I'm just going to read one. It says, just wanted to say a huge thank you to Gail. I found your presentation incredibly informative and really appreciate your time tonight. And I think probably all of us on the call here or on the Zoom feel that way. So thank you so much for participating.
Thank you for having me, and good evening, everybody.
Okay.
Bye.